Hi, everybody, and welcome to the inaugural um, Immigration Policies and Practice Q&A with moi, Nicolette Glazer. And I appreciate if somebody will join me. And this is my first time, and I, of course, do not know what I'm doing. So there will be some glitches until I figure it out. So I apologize for it. And I hope that you will forgive me the glitches today. Now, let me ask you let me introduce what I plan to do with these these weekly streams. I don't want to do legal advice. I don't want to do in-depth legal advice to in any immigration related matters, lawsuit. What I wanted to do is actually drive a honest conversation with people who may have interest in immigration, and mostly to dispel deliberate misinformation or some honest misunderstanding in a very, very complex area. So that's the purpose. And so, what I was hoping is that you will send me your questions. You can do so by DMing me at either Twitter or Instagram. You can find me under Nicolette Glazer, and I will try to answer questions that I receive in advance. Once I figure out what I'm doing, I will allow and be able to get you guys to live pose questions. And so I will be able to answer questions that actually of interest to anybody joining me. So that's kind of what I was looking for, informal format that is bringing or addressing issues that are ongoing in the immigration space, such as policies, regulations, impact litigation that is ongoing, and answering questions as to what people want to know, read about it, and didn't understand, and hopefully I'll bring you my perspective. Now, keep in mind, this is an open forum, so I will not be answering case specific questions, nor I'll be providing individual legal advice. But most importantly, please keep in mind that anything that is said is available to anybody. So please, please, please do not share any personal information, any information that you do not want the public at large to know. And most importantly, if you have an immigration case or are consider yourself vulnerable to immigration enforcement, please do not post any information or post any information that can be identified or can lead to facts about your case. And again, that is for your own protection and the fact that I am not providing you legal advice. Let me tell you first a little bit about myself. I am an immigration lawyer and a litigator. I've been doing that for a long time, starting 25 years. And I'm also a certified specialist in immigration law by the California Board of Legal Specialization. So, as you can probably surmise, I've been doing a lot of immigration and I've kind of seen it all. And so, I hope I can bring you some practical perspective to what's going on or may be thrown our way. And so, with that said, I was hoping and I was thinking that over the next few installment and this program, I will go over the day one executive orders. I already got some questions. I've been fielding a lot of phone calls from clients and prospective clients, so I kind of understand to a certain extent what is of particular interest and some of the misconceptions about it. So let's start with the big one, and that is the birthright citizenship executive order. Well, as you probably have heard or seen by a lot of post media coverage, you name it, it is a big thing, but honestly, it is really a political stint, in my opinion, and an opening political saldo by the Trump administration to lay the ground to actually, in the future, destroy birthright citizenship. But where we stand now, actually, it's very limited. The executive order is what it is, an executive order. So it can do absolutely nothing to amend the Constitution, which, as you know or have heard by now, provides citizenship to all persons born in the United States, subject to the jurisdiction of the United States. So Trump or any president cannot do anything to amend the Constitution. Second, the executive order cannot do anything to amend or abrogate the Immigration and Nationality Act, what I call the INA or Title VIII, which is the comprehensive statute passed by Congress, amended many times, that comprehensively regulate the field of immigration. And so the INA also verbatim includes the birthright citizenship constitutional formulation in the act. So by statute, all persons born in the United States, subject to the jurisdiction of it, are United States citizens. So nothing can be done about that law of the land, which is the Constitution, or the statutory by executive action. So, what is the purpose of this executive order? Well, in my opinion, it is twofold. First, it was something that the Trump administration and Trump himself has used as part of their political campaign. And so he promised and he delivered this, kind of made for TV moment, announcing that the federal government, starting February 19, 2025, will not recognize the citizenship of children born to two very limited classes of people. And so that was one aspect. And second is, I believe, is it actually already brought that result. It drives the conversation in the public, and with that brings congressional action. We already have at least one bill that has been introduced to restrict citizenship under the principle of jus solis to children of undocumented non-citizens. So obviously Congress can amend that, and what this executive order does is start the ball rolling on this. And so it's a very potent political statement, but beyond that, not much as legal consequences. So I think it's going to be short-lived because the courts will block it, and I'll talk to you about it later. But what it does, it spread a tremendous amount of fear and concern among pretty much everybody. So what I'd like to do is just quickly tell you what the executive order says and where it may go if courts are slow to act or somehow they do not block it because of standing. So the executive order basically, first of all, affects no one who is currently alive. So if you are born and breathing, this executive order does absolutely nothing about you. So it doesn't matter what was the status of your parents, your grandparents, or whatnot. If you are breathing today, you're born in the United States, you are a United States citizen, and with that comes all the benefit that United States citizenship brings. The same can be said that if a child is born between now and February 19, 2025, that child will benefit and become a United States citizen automatically. Now, what happens beyond that, assuming it is not blocked well before February 19, is that the executive order basically says that federal government will not be recognizing as the citizenship, meaning it will not provide proof of citizenship and will not accept an evidence of citizenship to a child who was born to a parents who are undocumented, meaning the two parents are both either I'm sorry, the parents are either without documents, let's say they've entered without inspections, or they've overstayed their visas. Now, the second category is a category of people, of children who were born to parents who are actually legal in the country, but temporary, meaning they are holding a temporary non immigrant status that covers tourists, H1B, H2B, O1, the whole alphabet of non immigrant visas. These are the two category of people who are targeted by the executive order. Now, it does not affect in any way mixed families, and by that we normally refer to people who are born or who have a spouse who is undocumented and the other spouse is a US citizen. The executive order also says that it will not affect mixed families in which one parent at least is a legal permanent resident, meaning holds a green card. So the people who could be affected or are victimized by this particular executive order are undocumented non-citizens and lawful temporary non-immigrants. Now, you can question the purpose or why would that be done? Why was it included? It's beyond the scope, and I have no idea what was going on behind it, but that's kind of what this executive order says and does. Now, what in practice, what they were thinking of them doing? Well, what they're thinking is that if they were allowed to do that, simply they will not allow children to get passport, because obviously once you're born you get your birth certificate from the state authority, whatever the form design that the particular locale uses, and you present this certificate and that's your citizenship generally. But the federal government is not involved in that process. What they're involved in is giving people a passport. So generally, many of you have done it, you take your little documents, including your birth certificate, and you apply for an initial passport, or you renew your passport. Well, if you file your initial passport, you have, for a child, you have to have a lot of information from the parents. You have to, and so what they basically are doing, hoping to be able to do, is to prevent children after February 19, 2025, and if it stands, to get those passports. And so without a passport, it deprive lawfully lawful United States citizen from one of the biggest benefits, that is to freely travel and return to the United States on a United States issued passport. So that is a huge, huge, huge benefit and a huge damage that they are trying to inflict. Now, that's something that only the State Department does. And so if there's a policy or they implement a practice, then people are not going to get those passports. Now, the courts, and we know they have already 4 or 5 lawsuits that have been filed, are likely to block that aspect of it because it causes an immediate damage and harm to a United States citizen once, they are born and they get to benefit from the fact that they're a United States citizen. So there's no way, in my opinion, that a court will, especially a district court, which is the trial level court, will allow that kind of executive action to upend, decades of practice and benefits that accrue to anybody born in the United States. Now, the other aspect of this executive order, which I believe was driving it, is that once a child is born and parents are undocumented, a lot of time the fact of the citizenship of the child allows, and down the road allows, the parents to benefit and obtain status. Now, as you know, there is a lot of talk, and Trump himself during his first administration, and no doubt will continue to rail about what he calls chain migration. And so I believe that's another aspect that they are trying to target through this executive order, because if it is allowed to stand, then a child born to an undocumented parent after the effective date will not be able to, after 21 years, provide a pathway for the parent to obtain a green card. Currently, as the law is written, a child who is a United States citizen and who's over the age of 21 can file an I-130 petition, which is basically a form of the USCIS. When approved, starts the process for the parent to become a green card holder, what's called an adjustment of status process. So, if children of undocumented parents or of a green card, or when the parents are temporary in the United States, cannot benefit their parents, then the parents who are here, like for example, people who have been here for many years, may have come with a visa, overstayed that visa, fell out of status, whatnot, they will not be able to obtain a green card based on the fact that they are the parents of a United States citizen. But more immediately, a lot of undocumented parents have the benefit to apply for other form of relief, immigration relief, based on the fact that they have a qualifying relative, such as cancellation of removal is one thing that is often invoked as a relief for a lot of people who are in removal proceedings. And so child born in the United States is a qualifying relative. So you have a lot of time will have a parent who may have been here without a status for over 10 years. And when they meet all other requirements of cancellation and they have a child who's a United States citizen, and then there will be an extreme and unusual hardship to that child, the parent can receive a grant of adjustment of status, a green card based on cancellation of removal. Much more complex. I will talk to you maybe another time about it. But this is the kind of benefit that a parent, an undocumented parent, can obtain if they have a child who's born in the United States. So by this executive order, the Trump administration is saying, well, if we are allowed to do what we want to do, then if you have a child who was born after February 19 and you, the parents, you guys are undocumented, you cannot use the birth certificate, the fact of the child's birth, as to meet an element that requires citizenship. And why I'm saying that is to meet an element that requires citizenship is because the federal government only deals with basically giving you a passport, which is an official international document that you are a United States citizen, and administers certain benefits to certain people that either arise out of or rely on the fact that a child is a US citizen. Sometimes this is, as I said, immigration benefit. It could be benefits such as Medicare benefits or Social Security benefits and other welfare type benefits that accrue to a US citizen child that are federally sourced. Beyond that, federal government has no business and does absolutely nothing to regulate the issuance of birth certificates and what a state will do with respect to what they consider a U.S. citizen for purposes of state administration, state law, and state benefit. But anytime that you have a federal source that gets involved, then the states will be hamstringed and they will not be able to provide those benefits to children who I'm sorry, children who were born after February 19 and their parents are undocumented, or they are temporary non-immigrant visa holders or status holders. I apologize. So this is the big impact and the political gambit that the administration was looking to do with this particular executive order. Now, on the legal side of it, there is very little, if any, support for what they're trying to do, and the allegation that the Constitution has been misinterpreted. Now, first, the executive has zero uh, place and job or authority to interpret the Constitution. That is left for the third branch, the government of the government in the United States, and that is the courts. So that's the first hurdle they're going to hit. And second is there is absolutely nothing as a precedent that support the position that the Constitution and the INA, which basically verbatim repeats the language of the Constitution, does not mean what it says, and that is that all persons born in the United States and subject to the jurisdiction of the United States are United States citizens. Now, the clause that they cited in the executive order and is being batted around is that subject to the jurisdiction of the United States. Now, I think the argument that they're going to make is that the misinterpretation comes into that aspect, that it means that you have to be legally in the country or to be in compliance with the law of the United States in order to be covered by the Constitution. And then if you're not covered by the Constitution because you are not a person or a citizen that the Constitution wanted to benefit, then you cannot be subject to the jurisdiction of the United States. Well, to my knowledge, there is no precedent or legal authority, meaning a case issued by the Supreme Court or, importantly, Supreme Court, that has ever addressed the issue that is posed directly by this executive order, meaning what is the application of the US Constitution with respect to birthright citizenship to children born to undocumented immigrant or temporary visitors. Now, the temporary visitor is a lot more clear cut because of the few cases that have been decided by the Supreme Court in that field. But for the undocumented, I'm not aware that they have addressed. I mean, there may have been some dicta, may have been some, off-sided commentary, but no case have specifically addressed it. But that said, there is zero that I have ever seen in any of the commentary that lends any support for the proposition that subject to the jurisdiction of the United States means anything other than excluding diplomats and their children from the scope of the provision, and that is because it's well settled and it's part of the INA is that children of diplomats, they are not covered and they do not obtain automatic citizenship because of the diplomatic immunity their parents have and carry, and the comity between states when it comes to diplomats being present in another sovereign. So that is the aspect that normally comes into play, and perhaps rolling bound in time to the time of the Constitution, probably nobility, people like the king, like a child of be traveling in the United States, somewhere of England, traveling somewhere and having a child or something like that. Their children are not going to be, United States citizen because, again, of sovereign implication. But beyond that, I don't think there is any credible support for the proposition that the Constitution carves an exception when it comes to the documented to the status immigration status of the parents. Now, as I said, there have been right now, I believe, something like 4, the last I checked, cases that have been already filed against the executive order. There's the first one, I believe, was filed by the ACLU in New Hampshire. There is the big case is the one that is filed by the state of Washington plus the city of San Francisco, I believe, and several other Democratic-led states that are challenging it from the perspective of a sovereign entity, a state. There is another case that was filed, I believe, by CASA that is on behalf of pregnant women who are due to give birth after February 19th. And there is another one, I think it was filed recent. I think it was in San Francisco. Another one that perhaps is from the state of California, on an agency with California, and I'm sure there will be others. And all of these lawsuits are challenging the executive order as being in direct abrogation of the Constitution, of direct violation of the INA, and some of them invoke the Administrative Procedure Act against the agency because the agency is involved, that is the Department of Homeland Security, Department of State, because the executive order directs, obviously, the agencies, ergo the federal government, not to recognize the status, not to issue documents, passports, and not to accept evidence of citizenship for these children that will be born after February 19. So with the APA, the Administrative Procedure Act, they are challenging the authority of this agency, claiming to be in excess of law, ultra vires, arbitrary and capricious, and not in accordance with the established legal precedent. I think one of them also had a cause of action against Trump under the APA, which is puzzling because it only applies to agencies, so probably that's going to be killed. But this is kind of what these lawsuits are shaping out to be. So it was going to be a purely legal question. Is the Constitution, permits the president to issue such an executive order and take the action that he's directing his agencies to do? Or, and second, is that in accordance, can it be square with the clear and unambiguous language of the Title VIII, the Immigration Nationality Act? I mean, I think to answer to those are clearly very obvious no, and I anticipate that a judge will declare that executive order is in excess of law and will order that it cannot be implemented. Now, one aspect that probably will be driving these lawsuits and the discussion is going to be standing. And I think for purposes of the state, I think the Supreme Court in the last few years have caused and stirred up a lot of issue as to what and who has standing when it comes to immigration policies and enforcement of immigration policies and practices. So the states may face a challenge to the extent that they do not have a cognizable injury. And I'm sure they're going to be pointing to the fact that nobody currently alive, meaning when the lawsuit was filed, is affected by this executive order. And second, that is a statement of policy, and ergo it's not challengeable under the Administrative Procedure Act. I don't think that any of the district court will buy those arguments. They're going to find standing, and then they're going to issue the declaratory judgment and prevent the executive orders to be enforced. We're going to know probably fairly soon, because I believe in one of the cases, I believe that's the Seattle-based case, the judge has scheduled a hearing on the preliminary injunction for tomorrow at 10 o'clock, I believe. A lot of time, Big cases are streamed, and so if you are interested, you probably could go to the website of the United States District Court for the District of Washington, and then you can see probably there will be either a tab with cases of interest, or they may be a tab that shows like how to attend a hearing or public participation or anything like that. And so you'll be able to probably find either a link that will lead you to a YouTube broadcast that the court may have, or some courts will not broadcast it live, meaning there's not going to be a video stream, but the people can listen to the arguments. I have a hearing actually tomorrow at that time, so I'm not going to be able to listen, but maybe in the next week I will figure out how to rebroadcast and talk to you about of what was going on with the hearing if we have not received a decision, which I believe is going to be coming very soon. So we're going to know fairly quickly where the judges are going to stand on those issues, because on a preliminary injunction, things get done very fast. I haven't seen yet the government's response. It's going to be interesting to see what their legal argument is going to be and what are they going to challenge and what is their support for the arguments and the basis to issue this executive order. So, it'll be interesting to see what they say. I'm sure it's going to be posted somewhere today, and I may post some commentary on Twitter. So if you're interested, follow up my Twitter feed, and I'll let you know what it is that they're arguing. So it's bottom line, as expected, we're going to have various district court judges issuing decisions on this issue. I expect that they're all going to be issuing the same decision, meaning the outcome is going to be the same. They're going to block the further enforcement of this particular executive order. And obviously the administration knows that that's coming. What they're looking for is to go through the appellate process and then end up at the Supreme Court. Once at the Supreme Court, obviously, then things will be very different, because the Supreme Court can change prior law. So they can disagree with the few precedents that have held that children born in the United States are United States citizen regardless of the citizenship of their parents. And the documented status of their parents. But they are the only one that have the authority to do so. They can abrogate prior cases, they can make new law, they can interpret the Constitution and say, yep, you're right, it excludes children of undocumented non-citizen, or they can go the other way and pronounce that the Constitution is clear and unambiguous and any person born in the United States is a United States citizen. But we have to wait for the Supreme Court to come in and, issue a decision. Now, that is not going to come very soon. Because, as I said, it's not something that is likely to percolate through the appellate court very quickly. They may try to speed it up by doing a stay and then taking the stay on an emergency shadow docket to the Supreme Court. It may work, it may not. Depends how the justices want to see that. It's a hot potato, so they may not want to get involved until the issue percolates through the different districts and the different Court of Appeals, because, as I said, they've filed for sure in the Ninth Circuit. There is, I think we're in the Second Circuit, and maybe they will file some in the Third Circuit. And so there will be a variety of circuit that will be able to opine, and I would think the Supreme Court would like to see that happen before they take on this particular issue. But as I said, it's a political saldo that the administration did, I think, which is effective already. because it is making this a major issue. So it will stay in the public eye and it will shape the public debate. And that has a tremendous amount of importance for anything that's going to come in the future. And it is already bringing results by the introduction of bills in Congress to strip undocumented citizens from the ability to have to confer citizenship to their children who are born in the United States. Now, one aspect that is particularly problematic for me with that is that the difference from the executive, Congress can pass law that will not pass constitutional muster, but if they were affecting citizens, but they would if they're affecting non-citizen. So under the plenary power, a doctrine that is always said to have constitutional underpinning, which I don't believe is the case, but nobody cares what I think. Um, Congress is the basically behind the wheel when anything comes to immigration. So it will be very different and will be in a very different posture if Congress managed to pass a law amending the INA to say all person born out of, parents who are U.S. citizen or green card holders are United States citizens. And if that happens, I think we're going to have a very much a different type of debate and posture. But we're not there, and I don't think we're going to get there anytime soon. So, in conclusion, on this particular issue, I would say, nothing is going to affect anybody anytime soon under this executive order. So, doesn't matter what your parents' status is. If you are breeding and you give birth to a child before February 19, your child and you are United States citizen with all the benefits that come with that. Likelihood is that after February 19, nothing will change from the current status quo and nobody will be denied an United States citizenship in the foreseeable future until the Supreme Court says otherwise. So I would say, on practical terms, you don't have to concern yourself. Now, from as point of interest, obviously it's going to stay as a big issue and a big discussion, but practically it doesn't affect anybody. That's my view. Now, with that, let me switch gear and go to the executive orders, the day one executive orders that actually do have immediate impact in the immigration space. And those are quite a few, and I'd like to go through them. And then bring some issues that may be of interest to you guys. And I already got a sense that a lot of people are thinking about it already and are concerned, and I will discuss that over the next few weeks. So first of all, with the invasion and the border, protecting the border executive order, they're all named the same. So I'm not going to use the actual titles because they're incomprehensible. But the big immediate impact are few, and they're very consequential. First, the one that is directly kind of to me that was the biggest right off the bat is that currently all enforcement priority restrictions are gone. So during the Biden administration, one good thing that they did is that they limited significantly interior enforcement, meaning arresting, like going out and arresting people who are inside the United States and placing him in removal proceeding, and also actively seeking out people who have final order of removal. So that is something that was really, really good if you are an immigration practitioner or if you are a non-citizen who does not have a green card. So all these restrictions, all these policies and practices kind of saying, well, unless you're a criminal and you have a felony, you are not a priority, all that is gone. So currently, if you or anybody you know has no green card and is at a status, meaning they may have come legally in the country, but they have overstayed their visas or they have violated the terms of their status, or they came unlawful without authorization, what I call the EWIs, entering without inspection. Those people are all priority, meaning that if they are encountered by ICE, they are subject to be arrested, they're subject to detention, and they are subject to be placed in removal proceedings. So that is an immediate change. And that is something that cannot be challenged in court, because that is a core exercise of the enforcement prerogatives that the INA, the statute, gives to the federal government and ICE. So the reality is people who do not have status are vulnerable. People specifically vulnerable are people who have a criminal conviction and people who have a final order of removal. Now, Homan, the border czar, has made it clear that people with felonies and people with final order of removals are going to be major priorities, meaning those are the people that they're going to actively go after. And then if they encounter somebody on the way, they're all fair game. So what we're going to see is we're going to see a lot more targeted and collateral arrest in the interior. Together with that, the thing that happened, which happened actually yesterday, is that they reinstated the expanded use of what's called an expedite removal, which is, again, a process where people who are encountered, originally it was started during the Bush administration, that if you are encountered within the border and you entered less than 14 days from apprehension, you are you should be placed in expedite removal. Then they extended it beyond the 100-mile zone, and currently everybody who's encountered and who has been in the United States less than 2 years is subject to this expedited removal. So what the executive order combined with this rescission of the ERUs basically are doing is that they are making everybody who is inadmissible or who is removable a target. Now, are they going to arrest everybody? Of course not. Are they going to arrest a small segment? Yes. But the point I'd like to make is that even if it's 1%, if you are within that 1%, it doesn't matter that 99% people were not affected. And also, the fact is that everybody who is in that group of inadmissible or removable is potential target. And the fact that you have lived here for 10 years, 20 years, the fact that you pay taxes, the fact that, let's say, you have a child who is a United States citizen, or you have a wife who is a green card holder, and you name it, all the equities that people have, means absolutely nothing for purposes of enforcement, immigration enforcement, meaning that if you come to the attention of an ICE officer, that ICE officer has the legal authority to arrest you, detain you, and place you in removal proceedings. And out of removal proceedings, there are two mostly likely outcome. Currently, we had a third one, but I think that door is going to close. Is you're going to get relief, meaning you'll walk out of immigration court and removal proceeding with a green card in hand, or you end up with a voluntary departure that can turn into a deportation order of removal, or a removal order. So there is no something like, well, it's going to be probation, or the next time they caught me, it's going to be. No, It is you get relief in the form of a green card or asylum, or you are basically told you have X amount of days to leave, and if you don't leave, that voluntary departure in turn into an order of removal, or you are handed directly the order of removal. So that is an extremely, extremely consequential fact that is brought upon anybody who does not have status. And also the fact everybody who has a parole, because a valid parole is parole until the purpose of the parole is completed. And the purpose of the parole is completed under the INA when an officer serves the person who holds a valid parole with a notice to appear, which is the charging document. So everybody who came under the Biden's pathways and currently has a parole document is also subject to enforcement. And there is absolutely nothing people can do about it. That is my opinion. Because after the Supreme Court decision in the priority case, it is clear that there is nothing states, individual affected non-citizens, organization can do to dictate who gets arrested and placed in a removal proceeding and who does not. So that is an incredible, powerful, and immediate impact of the day one executive order. The second one, to me, is the fact that the parole authority got impacted very much. And first is, we've already heard, is that the CBP1 app functionality that allowed people to make appointments from Mexico, and then once they get their appointments, show up at the port of entry and be processed and paroled into the United States. That functionality got suspended and stopped to exist within less than an hour from Trump's taking the oath of office. So the parole path that was in existence under the CBP1 is gone. Also, what they call in the executive order, the categorical parole programs were terminated. The executive order specifically named the Cuban, Haitian, Nicaraguan, and Venezuelan, the CHNV parole, has been terminated effective with the signing of the executive order. In fact, USCIS removed that particular portion of their website within few hours. But the last time I checked, U4U, excuse me, the parole program for Ukrainians remains. And the reason for that is because the U4U, the difference from the CBP1 and the CHNV paroles, the U4U has a congressional underpinning. It was created by Congressional Appropriation Act. So this particular parole program was always in a different footing. And although they mimicked and modeled it after the U4U, it was always different. And so to my knowledge, the U4U is still on the books on the USCIS, but practically, from what I have seen, and I'm not saying that that is across the board, my personal practical experience is that in the last year, there have been very few approval of the U4U. I've spoken to some colleagues, and it appears to be that at some point they pretty much stop processing them. It takes tremendous amount of time, and very few have been actually approved from what I know. So U4U is on the books, but I think it's pretty much inexistent only as a vestige of a very powerful and very good program. So parole is now returned to the baseline that was set by the Trump administration the first time, and that is case by case, and you have to really show either a medical emergency or an extreme case of humanitarian basis to get parole at the port of entry. Now, I'm not talking about advance parole, which is a kind of travel documents that people get as part of the pending adjustment of status application. That is not affected. Also, it's not necessarily as affected the authority of USCIS and ICE to release people who have passed credible fear interviews or who are detained and are not eligible for bond. That remains, it's a different kind, but again, we are probably back to that very stringent case by case that was in existence during the first Trump administration. So that is a major, major, major aspect, because the combination between the continuing existence of Biden asylum travel ban, the one from June, and the fact that all the pathways that they created were eliminated minute one. Currently, there is no available path to asylum to anybody who appears at the southern border. Well, why is that relevant? It is relevant because by executive action, what the administration has done is they have abrogated the Section 208 of the Immigration Nationality Act that makes statutorily asylum available to anybody who appears at the port of entry or enter unlawfully in between port of entry. Now, again, this is a statutory text created by Congress that has been in the books forever. And that the existence of asylum is now being entirely eliminated as we speak, because there is the asylum ban by Biden that remains in the books, and at the same time, we have absolutely no pathways in existence. And so people, as we speak, have no way to apply for asylum if they appear and they step foot on United States soil, which is at the port of entry, because all of our port of entries are on U.S. soil, or entering illegally and apprehended. I mean, again, a lot of people rail against asylum, and there's a lot of talk about fraudulent asylum claim. And yes, there is fraud in the asylum process. There is the majority of people who were paroled during the Biden administration under these parole programs are not going to get asylum because they're not statutory eligible for that. And that's why I've always called these pathways to nowhere. And I've been a very big critic of those pathways that Biden created, because they gave people promises and people don't realize that they are not going to receive a long-term status because they're not eligible for asylum. So yes, there are a lot of problems with the asylum, and you can take issues of it is, and it's completely antiquated. But the simple reality is that Congress has passed a law that makes asylum as a discretionary form of relief available to anybody, irrespective of the manner of their entry into the United States. And the executive cannot eliminate asylum. Now, as I've said, and if you ever followed me on Twitter or anything, I've kind of repeated that ad nauseum. The difference from withholding of removal and CAT, asylum is a discretionary form of relief that is left to the state, to every sovereign. So Congress can come in and eliminate asylum entirely, and that is absolutely permissible under international law, under the protocol, under the margin of appreciation within the convention and the protocol. But Congress has not made that choice. So asylum is a right. It's a statutory right that people can avail themselves. And the filing of an asylum application, as long as it is not frivolous, is guaranteed as an option under the statute. That has been eliminated by the combination, as I said, the executive orders on day one and the continuing existence of Biden's asylum bar. So that is a tremendous practical change and a sea change that is going to have an incredible consequences. In the immediate next, probably next 30 days, we're going to see a major humanitarian crisis. And over the next year, unless and until courts step in or changes are made, and we have a different setup in this particular thing. But right now, the situation is extremely, extremely dire. Now, as you know, some of them you may have heard, the various nonprofit organizations and plaintiffs who have been affected by the Biden asylum bar have challenged that, have even challenged the pathway regulation, and that is kind of working its way through the court. I think yesterday I saw that in one of the cases that is still at the district court level, they have asked for a hearing to address the CBP1 aspect of it. And as I don't know what exactly they're looking at, I didn't look at the paperwork, but I kind of have a question as to what they're looking to do and accomplish with it, because as I said, CBP1 is an app that was created. It has nothing to do with asylum. People get the I-94 with it. I mean, it's an app. It's a very useful app. But one aspect of it that was created by the Biden administration is to allow people to make this appointment for an orderly processing at the port of entry. And so if a judge, let's say, if I'm not saying that that's what they're asking for, but if they are asking for a judge to reinstate that particular aspect of CBP1, I kind of question what are they looking to, because let's say they're successful and the judge says, well, the Biden asylum bar is just nice and dandy because it gives this possibility for people to come in and show up at the border, 1,500 of them a day, and seek asylum. So it's not a total asylum ban, and distinguishing it from the original asylum ban that the Trump put during his first administration that was struck down by the courts. And so let's say they're successful in that, and CBP1 functionality of make appointment is put in. Well, that is basically to me, it's a one way to expedite that order of removal, because all that the CBP1 does is it allows people to make an appointment, wait forever. I mean, some people have waited for 6 months. And then when their time comes up, they are able to go to the particular port of entry and show up at the port of entry and say, here I am, I would like to apply for asylum. Because these people, they do not have a visa, they do not have any other form of entry documents, so they are inadmissible under Section 212 of the Immigration Nationality Act. And so, being inadmissible, they are subject to Section 235, meaning the only way that they can be allowed to proceed and be taken into custody is if they express an intent to apply for asylum and pass a credible fear interview. Well, under Biden, nobody was going through credible fear interviews. Nobody was applying for asylum, then didn't ask any question about eligibility for asylum. It was just the process to orderly allow people to enter, receive the parole, and then be allowed to apply for asylum in a normal path, which is the affirmative asylum process that is available for in the United States. So if they're able to return that functionality, they're not going to be able to return, and no federal judge is going to order the administration to just parole people simply because they waited X amount of months and got an appointment. That's not a basis to become admissible. And so all these people who have heard that a friend, a relative, or whatnot, in the last 2 years were able to, as long as they showed up with an appointment, be able to come in, receive a parole document, get a work authorization within 30 days, and all that stuff, will immediately find out that things have changed, and they will be first subject to detention, which is another directive of the executive orders, and that if they do not pass credible fear interview, they are subject to an expedited order of removal. Now, once that happens, these people are physically removed, and if they tried to re-enter, which probably many of them would, because that's what the cartels are selling people on, they will be subject to a reinstatement of order of removal, because the in expedited order of removal comes with a 5-year bar to be able to enter into the country, including applying. You're not able to apply for asylum, even if for some reason you were not able to do that properly. There are exceptions. I'm not going to go into that, but I question what is the purpose in challenging the CBP1, and I expect that that's not what they're doing, but it appears that they are opening the door for a judge to keep the case going by saying, okay, you can reinstate CBP1 and then do whatever you want. I mean, that is, again, setting people into another form of pathway to nowhere and a quick removal order. That's how I see it. Now, there's something else that I'm missing, and I'd be wrong. I'm not saying that I'm not, but that's kind of what I see as happening at the border. That's kind of the immediate aspect. And then the other one that I find particularly relevant is that by executive order, the administration announced that they are reinstating and restarting Remain in Mexico. That's the migration protocols. And that is a program that was in existence during Trump's first term. It was an extremely penalizing program. It was plagued with issue. It was completely ineffective, but it was a very much another PR move. It caused a tremendous heartache to people who are placed in these proceedings, because they basically guarantee a denial of your claim, although you are allowed to make it while made in Mexico. Now, in response of that announcement, and maybe knowing that announcement, Mexico did announce yesterday. There were some quotes and a video from President of Mexico saying, yes, they are ready to resume accepting both their own national who are deported and third country national. Third country national means people who are not of Mexican citizen or nationals that have been allowed to enter Mexico and present in Mexico and are attempting to enter the United States. So what that means is that whenever their functionality is ready, then they will be able to return people who showed up at the border or who are apprehended at the border. They will be placed in removal proceedings, and they will be given a notice to appear, and they will be returned or pushed back to Mexico to wait for their hearings and for their decision, meaning for their denials. Well, again, that is an incredible process, and it is a process that exists with basically no due process, statutory due process, and constitutional process. Now, obviously, people who are not admitted have very little constitutional protection, but they are supposed to benefit from the entirety of the safeguards that are in the Immigration Nationality Act. None of them really are in existence in MPP, which is the Remain in Mexico program. So that is something that is going to be another horrible, horrible development that we're going to be witnessing, and people who will be victimized by that program will suffer tremendously. Because once they return to Mexico, they are basically a prey for cartel and criminal organization. And we're going to see a tremendous amount of kidnappings, violence, extortions, and that is going to affect not only non-citizens, but a lot of relatives who are often US citizens, because people who were returned or people who were pushed back a lot of time do have relatives in the United States. And cartel sees that particular profile as a cash cow because they are able to basically extort US citizen, green card holding, people without status who are in the United States who will pay to have their loved ones, relatives, friends, whatnot, actually sprung out from the paws of the cartels and criminal organizations. And so we are going to see a tremendous amount of pain and suffering that is completely unnecessary, but that's where we are. So that's kind of the immediate consequences of the executive order. What all the other executive order basically do is set up a policy. You have the terrorist organizations, you have the visa aspect, you have the um, upcoming travel bans, you have the whole invasion thing. All that is a statement of policy with a directive for the head of the agencies to take action in a form of regulations, practices, internal policies, procedures. So these are kind of like the aspirational executive orders are really shaping what or giving you the tip of the iceberg of what is coming. Now, what actually is going to affect people is the regulations and cables and internal policy, special operating procedures that are going to be created, implemented. The problem is because of that form that they fall in love with the proclamations and executive orders, we have this executive pronouncement that is put out, but the first time the Trump administration will actually put the goals and what they're looking for in the executive order proclamation. We had the travel bans, we have a lot of that stuff that was happening. This time, I think they got smarter, and they are staying away from announcing an actual regulatory change. What it's expected, what I already talked about it, but saying, well, that's for the secretaries of the agency to do, which is the gap filling authority that is left to this agency and the head of this agency by Congress and the Immigration Nationality Act. And so the biggest issue I have with it, I mean, forget what is that they are setting in practice and what they're going to try to do, but it is the actual rules and regulation, because only regulations are put in the Federal Register, the special operating procedures, the cables that the Department of State will be issuing, a lot of the memorandum that go that interagency, those things do not get published. And so a lot of time we will not know about a secretive policy that has been implemented until it can trickle down to the petitioners and we start to see a pattern and it's like, oh yeah, that's what they're doing. Or it is leaked to a media or to an organization and whatnot. So in a way, that's kind of how we're going to be finding out what is going behind the scene and what actually the policies that are shaped and how they take form. So with that, and that's I'm going to end for today, say, if you're interested in this particular field, either because you think you are vulnerable and you want to be aware of what's going on, or you simply find this area fascinating, I would say find and follow reliable sources. And that normally is reliable immigration reporters who actually are, not reliable in the sense that they do have sources. They are investigative journalists. They actually go and work their sources to get information. So those are your source to follow for news. I'm not going to name people because that would be an unfair endorsement. I don't want to do that. But you probably, if you then, you know who these people are. Don't try to say, oh, this particular person has a particular political leaning. Not relevant. If they're good and if they have sources, they are a reliable form of information. Those are the people that it's worth following and crediting with information. The other ones that want to be immigration reporters are the ones that are basically parroting what the administration is fielding to the press because that's the information they want to be heard. These are not worth to read, but it's up to you, of course. And of course, people who are in the field, a lot of time those are the non-profit organizations that are dealing day in, day out, lawyers who deal with that. We see something that journalists don't see, and a lot of people who talk about immigration have no idea. So some of them are very, very reliable. So I will say find people that you find credible, people that kind of speak to you, people who have something to say, and people that you trust, and stay abreast of a system that is a Byzantine and it is full of exception to the exception to the exception. I mean, there's nobody who, I mean, virtually nobody knows all that there is to know that is in the INA. And so, you know, nobody can give you a definite answer. So, it's an interesting and fascinating field, but it is a tough field, and we kind of like daily realize, oh my God, I didn't have no idea that was there, or how did I miss that? So a lot of information is out there, not because people are trying to deceive, but simply it is the impression that or the reading you have of the facts of how the law applies a particular precedent. And then as you keep chewing on it, you find out, well, or talk to somebody or hear somebody's other argument, you realize, oh, no, I'm completely wrong with that. I didn't see that. I missed that. That's what the practice of immigration law is. So there is not an ultimate authority. But there is an incredible amount of people who are expert. So find the actual expert, and hopefully you will be able to have a good access of information to those areas in the field that are of interest. I will try my best to give you some information in my perspective, not claiming to be right. I have my biases, obviously. I am particularly critical of the bureaucracy that is dealing with immigration. So, I present a biased view undeniably. But I will try to give you my 2 cents and what I see, and point to certain things that I see are incorrect. And I hope you join me again. And with that, I say thank you, and I'll see you next Wednesday.